Farmers under an IRS audit can often have a hard time recovering litigation costs and fees. That's because the amount under scrutiny is often not enough to make it worth a legal challenge. Well, researchers at the University of Georgia successfully created the first hybrid of milkweed. Now, they bred the plant with commercially desirable traits that will ultimately do that. And we're going to get to that story in just a second. But let's go back to what we were just talking about and check in with Roger Owen, with the McEowen, with the Washburn School of Law. Roger, thank you so much for being with us today. And let's talk about some of this in our Rural Money segment. What are some of the main tax code requirements that play into all of this?
Well, good to be with you, Tammy. And indeed, there are 4 requirements that a taxpayer has to satisfy to recover litigation costs when battling the IRS. They have to be a prevailing party, that's one. And that also includes in that having a net worth not exceeding $2 million. They secondly have to exhaust all their available administrative remedies through the IRS process, not have unreasonably protracted or delayed the proceedings, and then make a claim for reasonable cost. And they have to satisfy all of those requirements.
Now, to be rewarded litigation costs, a taxpayer must not unreasonably protract the proceeding. So what exactly does that mean and entail?
Yeah, that basically means complying with all of the deadlines and not taking frivolous positions during the administrative process that don't have any basis in fact or law that would draw the process out. You have to participate with the IRS, meet all of the deadlines, go through their appeal process, and not get off on these tangents. Deal with the direct issues and go through the process. Then if you are not successful there, go into tax court.
So do you have a good example to share with us?
Well, indeed, there was a recent tax court case where there was really a very tortured appeals process. And I'm familiar with farmers over the years that have gone through this tortured process. This went all the way to the Taxpayer Advocate Service, the U.S. Treasury Inspector General for Tax Administration, went through 4 different IRS appeals offices. And ultimately what happened was that the IRS offered the taxpayer a settlement proposal, allowing most of the claim deductions that he wanted. He confirmed receipt of the offer, but didn't respond any further. But then 5 months later, the IRS Appeals Office turns the matter over to IRS Chief Counsel's office to prepare the case for trial. And then at a status conference a few days later, the IRS concedes the whole case. Well, after all of that, after all the process, the taxpayer then put in for costs because he's incurred tremendous amount of costs. And the court said, no, the IRS position was substantially justified. And by the way, you only get costs for court proceedings. This was administrative. So he's out of pocket all this stuff, even though technically he won the case.
Yeah, a lot of frustration there. That's Roger McEowen with the Washburn School of Law. Appreciate you joining us today.